Welcome back to this three-part series on the Coca-Cola termination case. In part one, we looked at frustration of contract, which leads in nicely to today's topic on the accommodation process and the concept of undue hardship. As you might recall, Coca-Cola terminated Shawne Hopkins 2 years after a workplace accident caused him severe injuries to his shoulder, arm, and neck. In the termination meeting, Coca-Cola told him that his contract was frustrated and accommodating his resulting disability met the criteria of undue hardship. In this video, we will go through the test for undue hardship and apply it to the facts as presented by CBC in their article about this case. Let's start by talking about the goal of the accommodation process. The objective of the process is to protect people from discrimination on the basis of a disability. And although most people may not think of a temporary injury or illness as a disability, the way human rights law has been consistently interpreted includes these as disabilities for the purpose of the law. In the case of Quebec and Montreal from the Supreme Court, Justice Leroux-Dubé put it this way, quote, "The purpose of Canadian human rights legislation is to protect against discrimination and guarantee rights and freedoms. With respect to employment, its more specific objective is to eliminate exclusion that is arbitrary and based on preconceived ideas concerning personal characteristics, which, when the duty to accommodate is taken into account, do not affect a person's ability to do a job." End quote. This duty to accommodate requires both employers and employees to engage in a good faith dialogue to find an appropriate accommodation that allows the employee to work without causing the employer undue hardship. Both parties are required to be flexible throughout this process, and there could be a range of acceptable accommodations that accomplish the purpose of the duty. For example, something I see in my practice would be where an employee needs time off during the workday to go to medical appointments for an ongoing condition. So we're not just talking about one-off appointments. One reasonable accommodation could be to allow the worker to work from home on those days, if that makes it easier to attend appointments. But it could also be acceptable to ask the employee to make up their time throughout the week or work less on the days that they have appointments. It really depends on the needs of both parties. One limit to this duty is that the employer does not have a duty to change working conditions in a fundamental way. For example, by creating a new position, but is required to arrange the employee's workplace or duties to enable the employee to do their work. The question then is, how far does the employer need to go to accommodate an employee's disability? There can be any number of factors that go into this analysis because this process is meant to be context specific. This means that we don't have a clear-cut test to run through like what we saw with frustration of contract. But factors that are often included include the financial cost of accommodation, the interchangeability of the workforce, and the interference with the rights of other employees, particularly in unionized environments where seniority is a factor. For instance, a small company with a handful of workers, all performing very labor-intensive tasks, may have an easier time proving undue hardship if we're talking about accommodating a physical disability. Whereas a large company with a mix of physical and non-physical positions available may have a difficult time in proving undue hardship. So if the small company wouldn't have work available for the worker or could only do so by completely changing their operations, that could meet the high bar of undue hardship. Turning back to the Supreme Court, their 2008 Hydro-Quebec decision put it like this, quote, "If a business can, without undue hardship, offer the employee a variable work schedule or lighten his or her duties, or even authorize staff transfers to ensure that the employee can do his or her work, it must do so to accommodate the employee." End quote. In that case, the court also says that something like chronic absenteeism could discharge the duty to accommodate, since the worker is unable to carry out work for the company, which goes to the heart of the employee-employer relationship. We saw a similar statement regarding frustration of contract, so you can see how these principles are closely related. But the facts that we have in the present case don't appear to meet that high bar. As I mentioned in part 1, Mr. Hopkins was cleared by the Workers' Compensation Board to return to work, just in a different role. Given the size of Coca-Cola, looking at the context, it seems unlikely that Coca-Cola wouldn't be able to find a suitable role for him at around the same level, but performing tasks he is able to perform. To put it another way, the essence of the employee relationship can be preserved without significant interference to the company's operations. Now, there's a lot we don't know about this case. It appears from the CBC story that there's no discussion or attempt to provide an accommodation, but it's possible that there were discussions that just weren't brought up in the article. Either way, it seems unlikely that Coca-Cola fully discharged its duty to accommodate to the point of undue hardship. As I've emphasized throughout, undue hardship is a very high bar for an employer to meet. But that isn't all for this story. The final piece that we're missing is the role of the Workers' Compensation Board in all of this, including the duty on the employer to re-employ injured workers, which we'll cover in part 3. Until then, check out my blog, linked below, where I go over the duty to accommodate in more detail. And like and follow so you don't miss part 3.